In this second session of today's seminar, we will enter in more detail regarding the role of the different actors in a mediation process, and we'll go therefore through the following points. We will see the overview of the actors participating in mediation. We will examine the mediator, the profile that the mediator should, and the qualification that mediation should have, the specific role, tasks, and duties of mediators during the mediation process, but also the role, tasks, and duties of other actors that participate in mediation, such as the parties, but also their legal representatives, the lawyers and the counsels. So at the end of this session, as we did with the first part of today's seminar, we will have a question and answer session where you will be able to ask your questions, and we will be able to discuss any points that you would like to highlight. So let me start now with the presentation of the main actors in a mediation process. So the main actors, of course, in a mediation process are two. We have on the one side the mediator, and on the other side, of course, the parties. Mediation takes place, of course, with the obligatory presence of the parties and the mediator. However, it is already, as we already touched upon it a bit in the first session of today's seminar, it is highly recommended, strongly recommended, that the legal representatives, the counsels, the lawyers of the parties are also present and participating in the mediation process. The mediator should encourage and manage the participation of everyone attending. That means of both parties and lawyers. It is important to mention that sometimes the parties choose to have two or more mediators for their case, who of course are called co-mediators. And as we already said, we will come back to this choice of two or more mediators further in this presentation. Regarding the mediator's profile and qualification, mediators are accredited by recognized institutions that organize trainings and provide mediators accreditation. It is, however, recommended that after the accreditation of a mediator, mediators should reinforce and keep on working and developing further their skills in practice with a continuous learning and practicing path. To this end, I can share with you the example of what we do here, the path that we use here in the Boards of Appeal of the EUIPO, that the training path, the continuous learning and practicing path that our mediators follow. So the EUIPO Boards of Appeal have been offering mediation since 2011. We will examine that, we will see that in tomorrow's session. Ever since, the office has been engaged in providing mediation training to its IP experts to obtain and enhance their mediation skills. So this includes what you see here on the slide. So first of all, our mediation receive their special accreditation training before recognized mediation institutions. And then as soon as they are accredited, they continue to learn and develop their skills. How they do that? They participate to mock mediation trainings to learn and continue to develop their skills through a live case scenario. Also, they have the possibility to participate to webinars and video sessions, and also observing mediation as observer mediator in order to take some lessons learned from other more experienced colleagues. There are also additional external trainings that are organized and for the EUIPO mediators, and also, of course, coordination meetings amongst EUIPO mediators in the objective to ensure consistency and harmonization of practices and share lessons learned between our mediators. The role and the duties of mediators, and we will be analyzing now the role and the duties of mediators. And let's start with the definition of the role of the mediator. So the mediator is a neutral third party to the dispute, and by saying neutral, this means impartial and independent. I will come back to that in more detail, what exactly impartial means and what exactly independent means. So the mediator acts as a process manager. So what does this mean? This means that the mediator helps the parties to reach a voluntary and mutually satisfactory settlement, so that the parties are happy with what they will be agreeing on at the end of the mediation day. He or she, the mediator, is also there to facilitate the communications and the discussions between the parties and their legal representatives, that they may participate also in the mediation. He is responsible of creating a good environment, an environment that is conducive to participate and to communicate and to exchange opinions and discussions amongst the parties. So the mediator is not a judge, and the mediator is not a legal consultant. So the mediator doesn't have the authority to settle the case, of course, on behalf of the parties. And of course, he's not or she's not there to give legal advice, to propose her own solutions, or to represent any of the parties. Additionally, the mediation cannot criticize the positions of the parties. The mediator cannot accuse their parties for their position, and is not there to spot the strong points or the weaknesses and criticize what the parties would like to achieve. So he or she are only there to guide the process smoothly towards the objective of a settlement that will be mutually accepted by the parties. So which are the duties of the mediator? The duties of the mediator could be synthesized in the following 4 points. So the mediator should, first of all, ensure confidentiality of the mediation process. Alexandra already mentioned the importance of the confidentiality and the fact that confidentiality does not cover only the mediator, but covers the whole process, all parties that participate in the mediation. Specifically in particular for the mediator, any information disclosed in confidence to the mediator by one of the parties should not be disclosed to the other party without prior permission. So if the mediator would like to transfer an information because they consider that it will help the discussion move on, they should ask for explicit permission from the party to convey this message to the other party. So they explicitly ask the question, would you like me to share this information with the other party? And as soon as they have the approval, then they could go and convey the message. Otherwise, whatever is not agreed that should be conveyed is directly covered by confidentiality and is considered to be confidential and should not be conveyed. It is important to say that the confidentiality covers also the entire process. So even the request to go to mediation is covered by confidentiality, and of course, up to the outcome of the mediation, the settlement between the parties. For example, in the EUIPO, the mediator is obliged to destroy any relevant information to mediation after its termination. Another duty is to respect parties' decisions, but of course, practice also what we call the reality check, which means that the mediator should, in principle, signal to the parties when their proposals are unrealistic. In other words, to put parties in the position to test the force of their arguments against facts that cannot be contested. In that way, the parties may reconsider their positions accordingly through checking with reality, through reality check. Another duty of the mediator is, of course, to show respect and empathy and do not favor any of the parties. This is what we call the element of impartiality, and this is considered to be a cornerstone of the cornerstone of the whole mediation process. I will come back to that in a moment. And finally, of course, the mediator should be neutral, and in the sense of not having any links, not having a conflict of interest, and as we say it, as we call it, of professional or personal nature with either of the parties. Again, this is an important, a cornerstone of element of mediation, the element of independence. In particular, regarding impartiality, the mediators must at all times act with impartiality towards the parties and be committed to serve all parties equally with respect to the process of mediation. It is important to act with this partiality and to be very clear about that in order that this message is really passed to the parties, and that the parties do not feel that they're in a certain way, they have the other party has an advantage compared to them, so that they could trust the process, and through trusting the process, the parties may reach an agreement. Regarding the element of independence and the non-existence of conflict of interest, the mediator throughout the process should disclose any circumstance that give rise to a conflict of interest. So it is important to say that this element of independence is also an element that should be respected throughout the process of mediation. This concretely means that the mediator may not have a conflict of interest at the beginning of the mediation, but it may come that something comes up during the process of the mediation, and there is a conflict, there are circumstances that give rise to such conflict of interest. So in that case, the mediator should directly declare this even in the middle of the mediation process. When we say conflict of interest, of course, this covers any personal or professional business case, business circumstances that may come up and with a relation with one or more of the parties. Or, for example, that the fact that the mediator has been a representative, a legal advisor to one of the parties, or even, for example, in the mediations that take place before the BOA of the EUIPO Boards of Appeal, that the mediator, for example, has been a decision taken of the contested, the decision under appeal, for example, at the first instance, or as an examiner. So this should be, of course, declared. So in case the parties, as we said, the principle is, of course, in mediation, the principle is that the parties are the decision makers. So if the parties decide that even despite the existence of a conflict that has been declared by the mediator, if they consider that they would like to keep this mediator, it's up to the parties to decide that they do not want to disqualify this mediator. So So it's the parties, again, that decide to keep the mediator and how the process will be and who is going to further advance the process. Again, this in the EUIPO Boards of Appeal rules, we take very seriously these elements of impartiality and independence. And for that reason, there are strict duties on impartiality and independence that are established by our rules on mediation. So the examiners and members of the opposition, cancellation, or invalidity decisions or other member of the Boards of Appeal cannot be designated as mediator if they have a personal interest in the case or if they have previously been involved in the case which is under appeal. Also, this concerns the future. It's not only what happened in the past or during the mediation, but as we said, it's a continuous obligation. The mediator should not be involved once they have participated in the mediation. They should not be involved in the future as an examiner, member of the opposition, cancellation, or invalidity decisions in any further proceedings that concern this specific case. So regarding the tasks of the mediator, the main tasks of the mediator can be listed as follows. So, of course, as we said, the mediator is the process manager. So that means that he or she guides the mediation process. They guide the mediation process via the organization of meetings, either with each of the parties, so bilateral meeting between only the one party and the mediator, or through the organization of joint meetings where both parties and the mediators participate. Since the mediator is the process manager, it's up to the mediator to decide whether there is a need to proceed with bilateral meetings, or at a certain point during the mediation day, it would be useful in order to advance more rapidly with the process to organize a joint meeting together with both of the parties. The mediator, of course, has the task to listen actively to the parties and asks to ask the relevant questions in order to move forward towards the objective of a mutually accepted settlement. So when we say listens actively, we mean that he or she should understand and show also that they understand what the parties say, the positions of the parties. The parties need to feel that they are being heard and understood, so that, again, this element of trust is developed between them and the mediator. The mediator also should help the parties to capture the overall picture of the dispute, not only the legal aspects, as Alexandra already mentioned, but also other aspects, for example, their business interests that may come out of the discussion, and the elements that might not have been taken into consideration. For example, a future business opportunity for cooperation with the other party. By doing that, by capturing the overall picture, the mediator is capable of identifying common ground for discussion, and of course, to take it further for possible solutions to the dispute. The mediator should also help the parties to prepare the offers, towards the other party. But that means also to evaluate, to discuss with the party and help them evaluate how their offer will be received by the other party. So it is up to the mediator to ask questions to one party saying, what do you think this offer, what would you think of this offer if you were the other party? How would you think this offer will sound to the other party? In order to do what we already mentioned, the reality check, if an offer, for example, is very far from the objective facts of the case. So this way, the mediator manages expectations and reactions by let's say, helping and assisting the party understand how the other party will receive what their position and their offer. Also, of course, since the mediator is not a decision maker, but is a process manager, he or she is exempted from the liability regarding the outcome of the settlement. So, and also, of course, the legality and the enforceability of the settlement agreement. This is why, to link it also to the question that was asked during the previous session, this is why the presence of the legal representatives of the parties is strongly recommended, because it's the role, as Alexandra will also analyze, the role of the lawyers to go through these points, the points of legality and the points, whatever has to do with the legal aspects, and also the enforceability of the settlement agreement. Finally, the main key to a successful mediation is for the mediator to explore the interests of the parties and not stay on the surface, on their stated position. So the key to find the solution, to find the way towards the settlement, is to discover what may be behind the surface of the conflict. So concretely, the mediator, by asking questions and through exploration, should look for interests behind the position and the strategies. So when we say interests, we mean what are the needs of the parties? What are the experiences of the parties, the values, the assumption, unstated opinions, but also what are the plans and the wishes for the future that the parties would like to ensure. And in that way, they help the parties explore a bigger picture, as we said. And exploring this bigger picture, through this exploration, it is that usually common grounds for discussion and solution and settlement appear. To sum up, we could say that an ideal mediator should present should demonstrate the following elements. So the mediator should be impartial and keep distance to the dispute without mixing his or her emotions to the discussion. They should ensure confidentiality. Mediators should ensure confidentiality. They should develop trust amongst them and between them and the parties, and through listening actively the parties. Of course, of respect parties' position and be patient. Show flexibility regarding the process, meaning that as the process goes by, to check whether it is more useful to meet with one party only or organize a joint session, and keep an open mind to explore possible different solutions, and of course, understanding human and business psychology in order to understand the needs and the interests behind the stated positions. And this is the case. We could talk a bit now about the case of co-mediation that we have already mentioned. So co-mediation is the case where the parties choose two or more mediators to work together on a specific case. it's not a matter of jurisdiction here, of different jurisdictions. It's more a matter of skills, let's say, and language. So some examples where co-mediation may be useful is when we have a complex dispute. So a complex dispute where a lot of parameters should be taken into consideration, or where we have different skills needed. For example, we could have a mediator that is specialized in trademarks, or a mediator specialized more in designs law, or which happens most usually in practice, language. So one party speaks a specific language, another party another, and they would like to have two co-mediators, each co-mediator speaking the language of the different parties. So it is important to say that co-mediation requires mediators, the two mediators or more, to work as a team. So they should be, they should have a harmonized practice. It is recommended that the roles between the mediators are agreed before the start of the mediation. It is also important before the mediation starts to have agreement on what exactly each mediator will do, and also to agree on how they communicate and they cooperate. For example, one mediator will be discussing one of the parties, the other with the other, and they cooperate, and they also would need some meetings, just the two of them, in order to discuss on how the process will continue, and discuss also the different messages conveyed by the different parties. It is also important to have agreements between the two mediators in order how to manage the process in case they disagree. So in case at a certain point during the mediation day, there is disagreement on whether they should continue with a bilateral meeting or a joint meeting, there should be already an agreement on how to solve, how to sort out this type of process management issues. I think I will now pass the floor to my colleague Alexandra, who will talk about in more detail on the roles of other actors in mediation, that of parties and lawyers. Thank you.
Let's look into the actors of the mediation, who are actually the stars of the proceedings, the parties and the lawyers. So now we're going to talk about the role and duties of the parties and lawyers, who are, as I was saying before, the stars of these proceedings. Now, just as good actors, parties coming to a mediation need to prepare before. What does this mean? Firstly, it is important that parties fully understand mediation. For this, since the parties are usually business people who are very knowledgeable in their commercial area, but might have never been in a mediation before, they may be prepared by their lawyers. Of course, they can also ask the mediator directly. Parties need to understand the principles of mediation so that they know what they can expect in terms of flexibility of the process, the requirement of keeping everything confidential, that the mediator is not a judge, what you've been hearing already before. In fact, before the mediation, the parties are asked to sign a mediation agreement, which at least here at EUIPO includes a confidentiality agreement. This obliges each party, as well as the mediators and lawyers, to undertake not to disclose any information that comes up in the course of the mediation. You will hear the word confidentiality all over our presentation. You will be up to here afterwards. The parties, as the interested persons in the dispute, must be aware of the important issues of the conflict, of the strengths and weaknesses of the case, as well as of their expectations. Parties should go into mediation with an open mindset. They must not only think of winning, but they should also ask themselves, what am I willing to give up? In order to negotiate, there has to be a willingness to accept suggestions from another person and to give up some of your own. This is the classical definition of give and take in negotiations. But for this, they must ask another question. What is essential for me? What is of absolute importance for me in this conflict? Moreover, parties must know before entering the actual mediation what their capacities and expectations are concerning costs and their chances of succeeding. I will now explain in more detail how we encourage the parties to prepare and to think about these questions in order to help towards a smooth mediation day. And as you will also see later on, lawyers will be mostly in charge of the legal aspects of the case, the preparation and the submission of the documents, and of the final settlement agreement once it comes to that stage. But let's look into the duties of the parties first. Firstly, especially if a party is a large company, it is very, very important that the person participating in the mediation has full authority to settle the dispute. In other words, it is essential that this person is able to make decisions on behalf of the company. It can be very frustrating when, after an advanced stage of the negotiation, it turns out that the person representing one of the companies does not have the authority to sign the settlement or to decide on a financial aspect of the agreement. So the issue of authority needs to be clarified by the mediator at the beginning of the process in order to avoid an unpleasant surprise at the end. It is, of course, not always easy to do, but failure to do so might lead to the failure of the complete mediation. Also, in order to increase the chances of a successful mediation, parties are requested to provide the mediator with a written summary of the dispute before the mediation takes place. The summary should include the legal issues between the parties, whether there are conflicts in several territories, or whether different rights are involved. However, this is not all that the summary should include. Let me go into a little bit more detail because it is a very important aspect in order to help for a smooth mediation. It is very important for the mediators that the parties provide information on the background of the dispute, where it originated, whether there has been a business relationship with the other party before, or even if there have been negotiations before. It is also important to know the background of the actual right at dispute. Perhaps it is a trademark that was originally created by the father or the grandfather of the holder. So there is an important emotional attachment to this name. Also, all this information will help the mediator to understand the party, especially its psychological and human side, already mentioned by Natalia, the psychological element of mediation. This will assist the mediation in facilitating an understanding between the companies in dispute, who otherwise would be fighting over purely legal issues without clarifying all these important aspects before. It is also very helpful for the mediator if the summary prepared by the parties, which obviously is generally prepared by the parties with the assistance of their lawyers, if it includes an evaluation of their expectations of an outcome. As mentioned before, negotiations are all about give and take. And the parties attending mediation must know what they're willing to give in order to be able to take So for this, before the mediation starts, what we usually do here at EUIPO is that the mediators prepare a list of questions. After reviewing the case, we come up with a list of questions that we send to the parties, where we ask them about all these issues mentioned. Has there been a relationship before, etc., etc. So the key of this is really, the more prepared all the actors of a mediation are, the higher are the possibilities of a successful outcome. Another aspect that goes without saying is that the parties are prepared to cooperate with the mediator, to conclude the mediation with a settlement in the shortest time possible. So we come back to your question before, there are situations where there's an abuse of the system, but what is generally expected is that parties cooperate, that they engage into mediation voluntarily and with the intention to resolve the dispute. Obviously, it can happen sometimes that there are very strong emotions with the parties, and that at the beginning they're a bit reluctant to cooperate. This can be when there is hurt pride or when there is mistrust from one of the parties. And therefore, it may seem that at the beginning, they're rather reluctant. In such cases, it is up to the mediator to find out about underlying issues, as mentioned by Natalia, and have this solved during the beginning. As mentioned also by her, mediators must ensure that parties are respectful in both ways. So when they are carried out by emotions and do not let the other side speak, or they interrupt the others, this would obviously delay the mediation and create more tension in the whole mediation process. And therefore, mediators usually ask the parties at the beginning of the mediation, please listen, do not interrupt. You will all get the chance to talk. Ideally, the parties are proactive. So they should not be afraid of making a first offer of the terms of agreement, right? Many times, especially when it comes to financial compensations or when we're talking about money, parties are afraid of making a first offer, as they believe that they will come through as the weaker part. And when parties have a conflict, none of them wants to be the weaker part, obviously. However, it is very important that the party makes a first offer in order to get negotiations going. And it is also to be seen that the party making the first offer, giving the first number, has the chance of establishing the range of the negotiation. This is what we call anchoring. And since the parties are expected to have prepared before during the course of the mediation, we will ask them about their expectations and maybe readjust them to the reality of the conflict as it emerges during the mediation process. A mediator will ask the party to identify the best alternative to a negotiated agreement, what we call BATNA, or what is for them the worst alternative to a negotiated agreement, that we call WATNA. So this would help us to do the reality check and to modify and adjust these expectations as mentioned before. In order to reach what we also call all these abbreviations, the ZOPLA, which is the zone of possible agreement, which would be a win-win situation, hopefully for both parties. So having said this, let's pass on to the lawyers in mediation. I understand that amongst the participants, there are also from private practice, and you may relate to this. Let's see if I get any comments after. It is often said that the lawyers are the gatekeepers of mediation. What does this mean? This means that if lawyers are not on board, if lawyers are against mediation or do not like mediation, their clients will surely not be either. And so what is the role of lawyers in this process? As I said, traditionally, it was thought that lawyers do not favor mediation, as it would take away the profit that they would gain with lengthy litigation. However, more and more, lawyers understand that mediation may lead to an easy and more cost-effective solution of the conflict, and that a happy client is better than an unhappy client. So they are becoming more and more advocates to mediation and favor it. A lawyer will assist the client at all times during the different stages of the mediation process. At least we encourage this strongly. And for this, he or she will have to understand perfectly the functioning of a mediation process in order to assist and educate their client accordingly. It is the lawyer's task, amongst many others, also to manage the time effectively in order to benefit the client with regard to the costs, because a lengthy mediation can obviously turn out being more costly than an administrative proceeding if it is prolonged in time. In order to assist what we mentioned before, the reality checking and the aforementioned identification of the whatna and batna, it is important that lawyers evaluate their clients' chances of success in the case of dispute, in case it should be resolved before the administration or the court, and explain this to the client clearly. Also, in the event that new legal issues arise during the mediation process, the lawyers must be prepared to reassess the situation and to keep the client updated in this regard. Further, lawyers should also discuss disclosure with the client. What does this mean? The lawyer and the client must agree on what will be disclosed during mediation to the other party and what confidential information will be shared only with the mediator. Of course, the lawyers must be aware and respect the principle of confidentiality ruling the entire mediation process. Lastly, lawyers are normally in charge of preparing all the documents, specifically those regarding the legal issues, as well as the initial case summary that I mentioned to you before, together with the clients. Lawyers need to prepare the client in identifying the important issues of the case. And finally, and most obviously, lawyers will be providing legal advice to their clients throughout the whole mediation process. Ideally, lawyers should take over the role of the mediator's ally. They should support the mediator in guiding the parties through the different mediation phases with the common purpose of reaching an amicable settlement. Lawyers should also assist actively in exploring situations and thinking outside the box. Lawyers assist, but as said before, it should be the clients who actually negotiate, as they are generally very experienced business people and very good negotiators. It is them who are the stars of the mediation, but all together we will strive to a successful outcome. It is actually a team spirit, teamwork that is to be done during a mediation conference and during all the mediation preparatory work. So I think this is all from me in the time being. Natalia and I are open to questions. Thank you very much for your attention.
Yes, thank you very much, Alexandra and Natalia, for your very clear and comprehensive presentation on the role of different actors in the mediation process. So now we will move to the Q&A session. I think we already received some questions from the audience. The first question, I would like to address this question to Alexandra. For the topic 1, you mentioned that mediation is not suitable for counterfeit and privacy. Can you have to elaborate more on that point, on this point? Yes.
Well, here we're talking about criminal actions, right? So it is public interest, and criminal action cannot be agreed unless obviously the party decides to take away the claim, but then it would no longer be a case pending before the court, right? So it can be solved between the parties if they agree not to dispute this matter. But if it is a criminal action, it depends also on the national law. It will be prosecuted ex officio. So these cases are generally not suitable for mediation.
Yes, thank you, Alexandra. Another follow-up question to these questions. So then in counterfeit and privacy, can they mediate for the damages?
Good question. Can they mediate for the damages? Well, if there is, I'm just guessing right now, if there is no provision against this by the national law, I do not see why it cannot. If I transpose this situation to the EUIPO, and for instance, the parties in a conflict want to mediate about the costs of proceeding before the EUIPO, there is absolutely no problem, and this can be included or be the exclusive matter, why not, of a mediation, right? I don't see any problem, at least here before us at the EUIPO, and otherwise I guess it would depend on the legal and the provisions of the national country.
Yes, thank you, Alexandra. The next questions is, I would like to address this question to Natalia. During the mediation process, is it possible or allowable for any party to request a change of mediators due to any reasons?
Yes, of course. The parties are, as we said, the ones deciding, the decision makers, even on the whole process, on the outcome of the person, but also, of course, on the person of the mediator, who is going to be the mediator. If the party, one of the parties, consider that they are no longer happy with, for whatever reason, with the specific mediator, they can ask for a change. Also, we should not forget that this is a voluntary process, meaning that they can also decide just to leave mediation. So it's a voluntary process which is not binding. As we said, what only is binding is when they already signed and documented the settlement agreement. But up to that point, everything is flexible, and there is a voluntary participation in the process from the part of on behalf of the parties.
Yes, thank you, Natalia. The next questions, I also would like to address this question to Natalia. In the selection of mediators, is expertise in a specific area of law an important consideration, or is it enough to rely on the lawyers involved?
I think Alexandra has already covered this, but I will completely agree with what it was said, that it's not obligatorily that the mediator, who is a process manager, is specialized in the IP field, let's say. But of course, it's a huge advantage for the process to have somebody who is a specialist in this field. Yes.
Thank you, Natalia. The next questions, I would like to address this question to Alexandra. Is the mediator allowed to review the settlement agreement?
So the mediator may be asked to review the settlement agreement, but the mediator does not give any legal opinion and does not provide any assistance in this sense. So the settlement agreement is totally in the hands of the parties and of the lawyers. So the mediator, if that would happen to me, I would say, I'm sorry, this is in your hands. Your lawyers will provide for the legal opinion, and they will know what can be enforceable, what is good for you, and you must know what is good for you. I mean, I admit, it has happened to me in a mediation where one party appeared very weak, okay? And the others were, you know, the classical, super aggressive company, a big multinational, and they had 3 lawyers with them and the CEO and everybody else. And the other one was a small, very small enterprise, right? A very small company. And I was seeing that they were actually benefiting from this weakness, that the agreement that was going to be signed by this other company was not so good, but I couldn't say anything. So all I could do during the mediation was ask questions. Do you agree with what is being proposed? What feelings do you have? Also, do you need some time to meditate about this? Do you need some time to think about it? Are you happy with what is there? Without hinting, obviously, on what I thought personally. So it's very important that we remain neutral and impartial. And we're all human beings, so sometimes I would say, oh, you know, and you know, as human being, you also like many times one more than the other, but this is a training that we have to do. And this is something that, this is why we train all the time. And this is why we have to interiorize all these principles as well, that we do not take any part. So we do not review the settlement agreement. We are not there in our roles of IP experts, although we might be IP experts. And if I may just quickly, that's come to my mind, compliment to Natalia's response before regarding the expertise. If, for instance, we would be mediating in a case, that would be wonderful, where there are also rights involved of, I don't know, for instance, of Singapore. So there's 2 parties who have a conflict for our office, the EUIPO, and they have also a conflict in Singapore, and they decide to mediate. What would be fantastic is if we would then do a mediation, a co-mediation, with a mediator from Singapore, so that both mediators are there. We have the expertise in the EU law, and then there's the Singapore expert. Now, this would be fantastic, and this is also a wonderful advantage of mediation, that we could actually cooperate amongst not only the offices but also countries. Thank you.
If I may, for this question, if allowed to review the settlement agreement, what the mediator could do is to ensure that all aspects of the dispute are reflected, the solution that has been accepted by the parties, that is reflected in the agreement. So that all, for example, different types of claims are discussed and agreed upon a solution. This can be, it's not reviewing the settlement agreement, but it's making sure that there are no, let's say, gaps that are not, that have been discussed and agreed upon, but are not reflected on paper. So this could be an important role of the mediator in this part of the last part of the conclusion of the settlement agreement.
Yes, thank you, Natalia and Alexandra, for your answers. Next, for this question, I would like to invite both Natalia and Alexandra to share your view. Theoretically, it is said mediators has no influence on the outcome of a dispute. However, it seems like in practice, mediators do have influence and can affect the substantive decision-making of the parties. What is your view about it, and what is your advice? Whether mediators should influence or not, and how far should they go?
Well, this is totally the eternal question, right? Especially for mediators who are part of an IP office, as in our case. Now, as I said before, we train this, so we have no influence on the case. This means that we cannot have been involved in the case before as examiners, as decision takers. So if there's a case pending before the boards of appeal, I work in the boards of appeal, but I have nothing to do with the case before. As a mediator, I would immediately put it to a side. And then it depends on our impartiality, and we observe the rules of mediation and remain impartial. It's like a judge, okay? A judge asks questions and tries to obtain information from the parties, but instead of taking a decision, the mediator, the only thing he does or she does is pass the information to the other side in a way that it facilitates a dialogue between the parties that otherwise would not have been possible, so that they themselves find the solution. So this is the great difference. We are not going to take part, we are not going to influence in any way. And this obviously is something that needs to be trained. But what we do is ask the questions. We do not give the solutions. We ask the questions in order to help the understanding between the parties. Natalia, maybe you want to complement this.
No, I think it's Alexandra. You covered it all. It's very important to also for the trust of the parties to the process to ensure that this element of impartiality towards the two parties and also towards the decision making of the parties, because the parties should be the ones making the decision. So this should be, let's say, this should be developed by the mediators' behavior throughout the process. So as the process goes on, this trust starts to build amongst mediator and the parties, and this should the mediator should avoid as possible from the human point of view, of course, to mix into the decision making, and also try to keep the certain distance that he or she needs to keep from the dispute. Yes.
Yes, thank you, Natalia and Alexandra. I think the next question also relate a bit to the previous questions. What should be the mediator's intervention? It could be more facilitative or evaluative from mediator point of view and from party expectations from your experience. Just in case you would like to comment a bit on these questions. Yes. And this question I would like to ask for Natalia and Alexandra.
I would invite Alexandra to start because she has a huge experience, a very long experience. So I will invite her to start, and if there's something to add, I will chip in afterwards.
Thank you. Well, let's see if I can. We've already been trying to explain this before. If I understand the question correctly, facilitative would be to assist party. So it's like when sometimes, you know, there's a teacher at school and you have two children fighting. I don't want to diminish in any way but the role is a bit to be there without taking positions, to help them to understand each other. This is why questions like, how do you think? One party makes an offer, okay, and says, okay, I offer the other party €1,000, $1,000 to solve this trademark conflict. And you know that the other party has been spending thousands and tens and hundreds of thousands of dollars already. So maybe you would say, you're not going to evaluate, but you're going to say, how do you think the other party will perceive this offer? Put yourself in the other party's shoes. Imagine that you received this offer. How would you think? So you help them to understand the other side. Okay, so this is facilitative. The same thing is when the parties tell you about the history of their trademark. What I mentioned before, it has actually happened to me that in a trademark conflict, it was created by the grandfather of one of the clients. Obviously, this is a huge, it costs more than money. It's a family thing, the trademark, right? So we facilitate, and I would ask the party, may I convey this to the other side? Can I tell them about this? Obviously, I have evaluated that it is very important, but I will merely facilitate an understanding whereby I will ask the other side, this has actually been created by their grandfather. Do you understand? Maybe they say, well, I don't give anything for this. I don't care. But maybe not. Maybe they will understand more and why it is so important. Maybe they will raise the offer. This is what I would think of. We have to remain neutral, but we have to think of questions they can be open questions, they can be closed questions, yes or no questions. And then we always have to ask for permission. Can I convey this to the other party? Sometimes we are like a messenger going from one door to the other when they're physical meetings, right? We would go from one office to the other. And now we do it mostly per email, but we will see this tomorrow in more detail.
Yes, thank you, Alexandra. Yes.
If I may here, to say it's also a matter of personal style. Some mediators could be more, let's say, challenging, going into challenging more the party's position than others. So it's also a question of personality, because we're humans, of course. It's a question of personality and of the style of the specific mediator.
Thank you, Natalia. Yes. The next questions, I think, is already covered in topic 1. Maybe just in case Alexandra would like to briefly mention again for the participants, what type of disputes mostly been referred to mediations in EUIPO?
Well, obviously, mostly they are trademark disputes. We have also had occasionally design disputes as well. As I said before, they always have to be inter partes proceedings, so there have to be at least 2 parties to the dispute. Concretely at EUIPO, this means there has to be, in the field of trademarks, there has to be an opposition, a cancellation proceeding pending before the Board of Appeal. And in case of community designs, there has to be an invalidity proceeding pending where both there are 2 parties involved. And then more things can come out as surprises during the first preparation meetings or the summary of the dispute, as mentioned before, that we ask the parties to prepare, and then some surprises can come up. So in order to initiate mediation in EUIPO, as we will see tomorrow, there has to be an appeal pending, and there have to be 2 parties. So these are the cases, and obviously mostly our mediation. I think Natalia, tomorrow you will talk about the statistics and everything. So there we will be able to give you some numbers. You have to wait until tomorrow.
Yes, thank you, Alexandra. We had a few questions left. This question also for Alexandra. As you mentioned in your presentation, it's very important to have the person with full authority in the mediation process. However, as you know, it's very difficult to involve them throughout the whole process. So what is your advice for this? In case for big companies like CEO, can they only involve in the final state? Yes.
Super pertinent question, because indeed, especially for big companies, this is a big problem. Normally, trademark matters, if we stay with our field of activity, are not the most essential problem a big company can have. Okay, normally a trademark dispute might be 0.0001% on the head of a CEO of a big company. So if their lawyers tell them, listen, you have to participate in mediation and be present for 24 hours even only, the CEO will say, no way, Jose. So what are we doing in this? Firstly, we inform the lawyers how important it is, because otherwise you will not be able to find a settlement. We will try to explore together with the lawyers, because our first contact at EUIPO is always with the lawyers. So we will explore together with the lawyers the structure of the company and try to find out if, first we will push for the top. So we will absolutely have to say, okay, in the preparation, the CEO does not have to be present. However, someone during the actual negotiation day has to be present who is able to take a decision in this matter, who has to be able to take a financial decision, etc. If not, the person participating in the mediation has to be able to contact the person taking the decision during that day. So we need some kind of undertaking by the party who has entered mediation and knows what mediation is about and knows that it is a dialogue with the other side and an active negotiation with the other side, that there is some way of finding the possibility of reaching this settlement. Now, actually, I'm just remembering a case. It was not a big company. It was a family business. And the son came to the mediation. This was a mediation we did in the UK with the UK IPO. And we were it was about a design that they claimed that they had designed before, funny object, I don't remember what it is. And we were very close to reaching an agreement whereby money was involved. Most of the times, I tell you, 90% of the times it comes down to money. So, and then he said, and I was so happy because it was really late and I was tired. And finally we were going to reach the agreement. And he says, sorry, I have to call my father because I can't sign this. It's like, what? You cannot sign this? The impression it made on the other side was devastating because they thought that they had been, tricking them the whole time, because you can't be present in a mediation without having authority. What does the other side think? Who's gone there with their CEO and with the decision-taking party. So this was really difficult, and we tried to, we did a break. We said, okay, please, I hope your father is still awake at this time. He was maybe 95 years old and already asleep. So it was like not very pleasant. So this is a point that mediators have to be very, very conscious about during the preparation. This is why preparation of a mediation is so important. But obviously, things can happen that go wrong.
Yes, thank you very much, Alexandra. Next, we will have two last questions for our session today. In case you still have any questions, we are happy to address them in the session tomorrow. So the next questions, what should mediator do when one side concedes with high amount of money? Can mediator offer the reasonable amount? For this, I also would like to address the question to both Alexandra and Natalia. Yes.
So I would say that the mediator should never comes up with sums and amounts. And on the other side, in order to, let's say, do the reality check of the amount that this party suggests that they may seem very high, you can, what we do is to ask the party, could you please break down to me how did you come to this amount? So the party will explain to us that I have added this and this and this, and through discussion, we can together, we can lead the party to do the reality check of the number that they have suggested. So in that way, they can understand by themselves that some of the things that they have added up may not be what the reality is, will not be really facts that cannot be contested. And on the other, also, additionally to that, we could also try to ask the party to put themselves on the position of the other one. So how would you feel if you are going to receive this type of number? So that they could, let's say, manage their expectations regarding the number that they bring forward, so that they can understand if they're realistic or not.
Yes, thank you, Natalia.
Yes.
Alexandra, you can go ahead. Yes.
Thank you. No, I really like that you mentioned this question that we asked Natalia. What we say is that, can you please break this up for me? Why, for which reason did you come to this amount? That is very good. And we should do that. This is our role of asking questions, because this is actually a tricky question that the participant stated, because the reasonable amount, as a mediator, I'm not going to decide what is reasonable or not. I mean, this is not me to evaluate, okay? I would simply ask the questions as said by Natalia. No, how did you come to this sum? Do you think it's reasonable? How would you accept it? What do you feel about it? But it's not for a mediator to offer a reasonable amount. And with the bargaining and the amounts, it's funny, we do not offer a reasonable amount. What I have done before, when a party is not inclined to accept and closes, and says, I am offended by this and I want to leave the mediation, and maybe let's say that the other party offered $10,000, right? So what I have done, I written on a piece of paper $10,000, and I said, okay, you have $10,000 now in your hands. If you walk away now, we will stop mediation completely. Take this with you, take it home, and then you will see. How will you feel tomorrow when you see that you could have had $10,000? So you see, we do challenge, but we don't take sides. We only push depending on the phase of the mediation, right? But I've done that as well. Sometimes we go to extreme. It's like 12 o'clock at night, and you say, I can't do this anymore. Let's,
Yes.
So, but we do not judge the amount, whether it is reasonable or not.
Yes. Thank you very much, Alexandra, for sharing with us the real case example. The last questions, I think this question will be covered in the topic tomorrow, but maybe if Alexandra and Natalia could have maybe spoiler a bit for these questions. In EUIPO, is a mediator assigned by EUIPO or selected by the parties from a provided list? Are the mediator only from within the EUIPO or also include private sector mediators? Yes. I would like to invite either Alexandra or Natalia if you could have to answer these last questions. Yes.
This is indeed something that we will talk about tomorrow in more detail, but just to give you a bit of a taste, I would say that the principle, the cornerstone of the mediation process, as we said, is that the parties have the privilege to choose the person that they would like to have as mediator. So indeed, the mediator in EUIPO is selected by the parties from our list, of course, of accredited mediators.
Okay. Yes. Thank you very much, Natalia. And we also would like to thank you very much, Natalia and Alexandra, for your participation and sharing knowledge, as well very real case, like practical examples during our last 2.5 hour section so far. So we would like to close the Q&A session to date, and also to close the today's session.